me start by saying good morning to everyone. Hopefully you all are doing well. As you notice, we are not wearing masks up here, and that's because we're all vaccinated. And if you are vaccinated, you are free to remove your mask if you choose to. This court granted the motions or the request to hear two matters involving mask mandates in our original jurisdiction. We agreed to do that for the simple reason that these are important issues to the community involving the health and safety of the community on one side, to the rule of law on another. Now, we know that people in the medical profession and politicians may have a different view of what these provisos may say. But rest assured, we are not medical professionals, we are not politicians, and any decision that we make will be based purely on the rule of law. Are you prepared to go forward?
Yes, Your Honor.
Thank you very much. You may proceed.
I'm Emory Smith for the State Ex-Rel Wilson. Bob Cook would be with me today. Bob wrote substantial parts of the brief. He's had some health issues recently, and he's doing okay, but he thought it was best that he not attend.
Mr. Smith, before I hate to interrupt you at this point.
Yes.
But these are serious matters, and they're serious matters to all concerned. And as you well know, that this bench is usually a pretty hot bench.
Yes,
and over the last 3 or 4 years, it's gotten a little warmer. So we're going to give you a few minutes to start to argue your case before we start questioning.
Thank you, Your Honor. I appreciate it, but please, of course, I welcome any questions anytime you're ready to ask them. I appreciate Your Honor's comments at the beginning. We're here not for purposes of weighing in on the health care debates or the wisdom of the policy behind the proviso. We understand that there are many concerns out there among the community about the spread of COVID-19 and its variants. We're here to argue the law, and we believe that the law is on our side, Your Honor. We believe that the ordinances of the city are in direct conflict with this proviso. The Creswick decision recently decided by this court said that there was a clear intent in this proviso to prohibit the use of state funds for mask mandates. It said that the General Assembly, with regard to this proviso, showed that it was capable of drafting a proviso prohibiting mask mandates. That's what the General Assembly has done here. Now, the city has put into its ordinance, I believe, that it will provide masks. And it has also said, I believe, that they will use the fire marshal to enforce. I'm not sure how the fire marshal gets to do that. He certainly can't be in every school all the time, or even every classroom. We believe the state funds here are certainly going to be used in the enforcement of.
Is that a factual issue, though, Mr. Smith? I'm with you. I mean, it seems pretty and incomprehensible to me how state funds would not be implicated in enforcement, but we have the city saying they will not, and we have you all saying they will. Isn't that a factual issue? And how do we make that factual finding?
Well, I think Your Honor can look to the law, and the law, I believe, is clear on that. Within the ordinance itself, it authorizes fines for personnel who fail to comply with the mandate, and it defines personnel to include principals, vice principals, and other staff.
It goes further than that, Mr. Smith. It says person shall, after defining person, principal, vice principal, etc., person shall be defined as any individual associated with the school or business who has control and ability to enforce the requirements of this ordinance. It then goes further and says the person may also include employee or other designee that's present at the business that does not have the title of principal, administrator, manager, supervisor, etc. So I don't know what etc. is, but anyone who they can put in the parameters in the school is charged with enforcement of that.
That's
How
correct.
does that not invoke the spending of state funds?
We believe it does invoke it, Your Honor. These provisions are state fund, these positions are state funded, and it's clear from a reading.
And if anyone contested the citation, they would automatically, I would think, do so in municipal court. And if they didn't agree with that, they would go on up through the state judicial system, which also would implicate state funds, would it not?
Yes, it would, Your Honor. And I think we can, it doesn't take too much of a reach to conclude that teachers would be at the front line of this in their classrooms. The teacher would be up to the teacher to say, put your mask back on. You didn't respond to my request to put the mask back on, so you go down to the assistant principal. And there's a line forming the assistant principal of all the school children who are sent down there. And then if the children still fail to obey, then there are disciplinary sanctions, possibly the involvement of the school district board of trustees in hearing appeals from disciplinary action against the school. So I think it's quite clear from this and state law and state funding, including the provisos in the Department of Education's appropriations that direct state funding of public school teachers, that funds would be involved.
Let me ask you a question about state funds. The words state funds is obviously in the Crestwick opinion, and you've mentioned state funds, and some of the questions have mentioned state funds. The proviso, which is on the screen here, says funds appropriated or authorized pursuant to this act. What does that encompass other than tax receipts or other funds that come from state citizens? It includes federal funds too, does it not?
Yes, it would.
Explain that to us, please.
Well, if the legislature appropriates the money, regardless of whether it's state or federal, then it, or perhaps even if they, I'm not sure if the local would be involved, but it would certainly implicate that proviso. In the Edwards decision, the legislature appropriated federal funds coming to the state and directed that the governor apply for those. The governor declined to do so, and this suit resulted, and the court said the governor had to comply with the proviso.
But the federal funds that are routed to a state, such as South Carolina, are they appropriated or authorized pursuant to this proviso?
They would, if they were appropriated or authorized by the Appropriations Act, then that would trigger the application of that proviso.
But that's if. The question is, were they? Now, I hate to refer to the brief of Mr. Pillows in the next case, but he specifically says, upon the information and belief, funding from the federal government pursuant to the American Rescue Plan Act, elementary and secondary school emergency relief received by the state was dispersed directly to the Department of Education to be distributed to schools.
That may be the case, Your Honor, but if the legislature included that in its appropriations, and I believe it typically does include federal funds in the appropriations, then that would trigger it. It also...
There's a whole lot of ifs going on here, and it seems to me that somebody would have taken the time to narrow this down to some certainty as to whether specific funds are, in fact, included in the 2021 Appropriations Act.
Well, I believe I can be specific, Your Honor. Under the Department of Education provisos in the Appropriations Act, it says that state funds shall be used for teachers' salaries, and it specifies the amount of those funds that are to go to teachers' salaries. So it's there. It is in the Appropriations Act. Regardless of whether there are additional federal funds, it says use state funds for teachers' salaries.
Are they saying you can only use state funds for teacher salaries?
It specifies that they are to be used for that purpose.
No, the funds appropriated in the Appropriation Act for that purpose are to be used for teachers' pay. What I'm asking you is specifically, can teachers' pay be supplemented by other funds?
I believe that it can be supplemented, Your Honor, but I think state funds are to be used under those provisos and other provisions of state law.
But that's clear, Mr. Smith, but the problem here is this proviso restricts the use of funds appropriated in that particular year's budget not other funds. So now, are you telling me simply because it's there, restricting state funds, no other funds can be used for that purpose?
Well, Your Honor, it would have to be, in order not to avoid that proviso, you would have to pay each and every teacher the teacher's full salary from funds other than state funds.
Says who?
Sorry, what?
Says who?
Because the General Assembly says that state funds are to be used to pay teacher salaries.
Appropriated dollars on the budget are to be used for.
Yes, Your Honor.
That does not say you can't use other funding for salaries.
I don't know that it does so, Your Honor, but I believe that there are special formulas in there about the use of local funds to supplement teacher salaries. And I think it's respectfully would be completely inconsistent with the state scheme for funding school personnel that you could have every teacher funded by purely local funds.
And you're saying
inconsistent.
it would be a practical impossibility to separate the various sources of funding, but you're saying you do know that state funds or appropriated funds are used to pay teachers.
It is. It's in the provisos in the Department of Education's budget. And I think this goes to the Hampton v. Haley decision that we cited in our brief. A school district could not decline state funds for teacher salaries and say, well, we're going to pay them just out of our local funds so that we can have this mask mandate.
You're an artful dodger, Mr. Smith.
I'm sorry, what, Your Honor?
The question here is whether or not supplemental funds can be used to pay teachers. Now, you have to admit that teachers in Greenville are not paid the same as teachers in Bamberg. So now, if what you're saying is true, they would all make the same pay. They make the same base pay, but they don't all make the same pay.
I'm not saying, Your Honor, that they all make the same pay. I'm saying that they all are paid by state funds pursuant to the provisos in the Department of Education budget and the general statutory scheme for payment of personnel.
What you're saying is that they're all paid in part with state funds. And the chief is exploring where the supplement comes from and what's the significance of the fact that there might actually be two sources of funds that are used to pay teachers.
Respectfully, I don't believe it's significant because they would have to be paid at least in part, if not in full, by state funds. And the fact that they might also receive local funds would not change the application of that proviso because it says no school district may use any funds.
Well, so you're not relying on the claim that teachers are paid exclusively out of state funds. You're relying on the point that teachers are paid in part out of state funds.
They are paid at least in part, maybe in full by state funds.
At least in part. And I suppose what you're telling us is if a teacher is paid $1 of his or her salary out of state funds, then that implicates the proviso. Well, let me go back to what Justice James pointed out. We probably shouldn't be using the phrase state funds. We need to use the phrase funds appropriated pursuant to the 2021 Appropriations Act. $1, you say, invokes the proviso.
Yes, Your Honor, but I think if you look at the proviso in the Department of Education's appropriations, and it may be 1.1, then and the state statutory scheme for the payment of teacher salaries, it's clear that it is more than $1. It is clear that it's a substantial, if not full, a substantial share of the payment of teacher salaries.
Well, let's say they are paid differently. Apparently, the argument's coming at you that, well, this teacher who is mandated by law to enforce this mask mandate ordinance receives X from the state and Y from other sources. And so we're going to say that when the teacher is putting his or her enforcement hat on, that teacher is earning the Y dollars from funds appropriated outside of the state legislature. How does that fly?
Respectfully, Your Honor, I don't believe it does, because I think you have to look at the clear intent here is that if it's state-funded dollars are going there, they can't do this. And I don't think that it would be, I think it would be respectfully inconsistent with that intent if a school district attempted to say, well, we're paying teachers 10% local and they can devote 10% of their time to enforcement of the mask mandate and using those local funds, and therefore we're not using state funds. It's all intertwined. It would be it's not a one-time thing. Students are in the classroom with the teachers all day long. They're subject to the assistant principal all day long. I don't think it could be compartmentalized, and I don't think that's what the General Assembly intended there.
Mr. Smith, from listening to you, it appears, and correct me if I'm wrong, that you have concluded that this proviso does not prohibit mask mandates per se. It prohibits using state funding from that appropriations bill, the 2021 appropriations bill, to enforce or announce mask mandates. Is that correct, sir?
That's what the proviso says, Your Honor. But I think it's a clear intent that this not happen. And I don't think it would be consistent.
Let me make sure I understand your argument, Mr. Smith. You don't really use the term conflict preemption in your brief, but in so many words you do. You say that the proviso and the ordinances are in conflict.
Yes.
And therefore the proviso is preempted. Whereas your opposing counsel says, well, they can be both construed in harmony with one another, not in conflict. Is that pretty much your argument, that you can't have an ordinance that conflicts with a valid constitutional, and I understand there are challenges to that, but proviso?
That is correct, Your Honor. The school district could not comply with both the ordinance and the proviso, and therefore the proviso prevails.
Well, explain that to me, Mr. Smith. If the proviso prohibits the use of funding from the 2021 appropriations bill for enforcing or announcing a mask mandate, then how is it that the conflicts preempts the city of Columbia, the county, or any other municipality or political entity from enforcing or putting out a mask mandate? How does it do that? All that proviso does and all that it can do is prevent the utilization of money from the 2021 Appropriations Act for that purpose. Is that not correct?
That's what it says, Your Honor.
I didn't ask you that. Is that correct?
That's what it says, that it directs using those appropriations. It does, Your Honor, but the city cannot direct the school districts to violate the proviso.
Wait a minute. Well, that's a good point, and I agree with you. But tell me, how is it that the city is directing the schools to violate the proviso? Now, Justice Kittredge made a good point when he went down the list of people who would be responsible for enforcing it or held accountable if it's not enforced. But how is it that the city is forcing that?
The city is forcing it because it'll fine those people if they don't comply with their ordinance. It'll fine the principal, the assistant principal, the teachers, other staff that's involved in it, potentially school board members, any of them. It would be forcing them to follow their ordinance or be fined, and that would be contrary to that proviso.
I want to follow up on the Chief Justice's question about your position as to whether this proviso prohibits only the use of appropriated funds, or does it in fact prohibit the mask mandate? And I'm doing this in anticipation that Mr. Kinney is going to pursue his argument that this is a violation of the one subject rule. And I think what you have said is that it technically prohibits the expenditure of funds, but practically it actually prohibits a mask mandate flatly. And I'm not saying there's a problem there. I'm just wanting to make sure I understand your position.
That is the effect of it, because state funds would necessarily be involved in enforcement because the state
Appropriated funds.
Appropriated funds, because
So
appropriated funds-
now, go ahead and respond to, so Mr. Kenny's drooling over there because you just walked right into his one subject rule argument. Why don't you go ahead and talk to us about why that doesn't make this a one subject rule violation?
Because state appropriation funds have to be used. The practical effect comes from the fact that state funds are used, but the proviso requires that state appropriated funds be used over that. And I think in an earlier question, we talked about how it's not possible really to see how appropriated funds would not be used here, because the proviso applies to the ordinance.
But what do we do, Mr. Smith, with the fact that the school districts and the city tell us they will not be used?
Well,
And you say they will, and seems like you're probably right to me, but how do we bridge that disagreement in the facts, whether they will or they won't be?
well, the disagreement is that although the school district says that it will be sending masks around, that the fire marshal will enforce, that's kind of, I don't know how that would happen, but anyhow, that's what.
Well, but does that matter that you don't know, or we don't know how that would work?
It does not matter, because as we've pointed out, it fines school personnel who fail to enforce, who violate the mandate. So that would mean the teacher in the classroom who said, you know, I disagree with the city ordinance, and you take off your masks if you want to. And the assistant principal says, we're just not going to tie ourselves up with disciplinary issues involving you. You don't have to wear your mask. All of them would be subject to $100 fines.
Let me ask you a question. Because of the utter clarity that you think 1.108 delivers to us, do you, and you can say I respectfully refuse to answer this question in this setting, you're saying that our decision in the colleges and universities case was absolutely correct? Or you can respectfully refuse to answer that question?
Your Honor, I respectfully decline to answer that, except that we respectfully disagreed with the conclusion about the university ordinance, but we do agree with the language in that opinion that said that this proviso is clear.
No, that wasn't the point of my question, but I thank you for your respectful refusal to answer the question.
Thank you. My time is at an end.
But we're here again from you in reply.
And relay to Mr. Cook our best wishes on his recovery. We sure miss him today, and you've done a great job in his stead.
Thank you. I appreciate it.
Mr. Kenny.
Thank you, Chief Justice Beatty, and may it please the court. I'm Chris Kenny here on behalf of the City of Columbia. I'd like to very briefly discuss the text of the proviso before turning to the issue about the funding and the Appropriations Act.
We're going to give you a few minutes to do whatever you like before we start questioning. We didn't give Mr. Smith much time, but hopefully we'll give you.
I don't need much, Your Honor. Thank you. With respect to the proviso, this court was correct in Creswick that what it does is it restricts the use of appropriated or authorized funds by school districts. What the City of Columbia has done here is they have taken the obligation of funding and enforcement upon itself. I'll return to that, but I do want to address, Justice James had a number of questions about the Appropriations Act, and Justice Hearn, you expressed some concerns about the record, and let me address those items this way. The Attorney General is factually incorrect about the funding at Richland 1. Here is where the funding comes from. There is approximately 38% of the 21-22 budget that is appropriated by the General Assembly. That is state money, and it is federal money that is given to the General Assembly to appropriate. That is our understanding of appropriated funds in the context of this proviso. There is a much larger 57-58% of the Richland 1 budget that is local funds and federal grant funding that does not go to the General Assembly for authorization or appropriation. That money goes to the Department of Education It has guidance by the federal government as to how it's used, but there is also a substantial amount of local money. And as an example, if we look at a pre-pandemic year, 2019, 2020, for example, 2/3 of the Richland One revenue was local money. So, with respect to what the General Assembly has done in Proviso 1.108, all they have said is do not spend our money on a mask mandate, and the city's ordinance complies with that entirely. Now,
What about the enforcement mechanism?
yes, Your Honor.
I hate to interrupt you before you got 3 minutes into your argument, but you brought up a point that is obviously a concern of this court. What about the enforcement mechanism?
Yes, Your Honor. The enforcement mechanism is, the city has taken that on. And just to give the court a sense of what is actually happening out in the community, the fire department chief and 11 of his inspectors have been visiting local schools. They've visited 10 public schools and 1 private school. They're using the fire department's mascot, Sparky, as part of an education campaign.
Okay, show us where that is in the ordinance.
Your Honor, that is not spelled out in the ordinance. That's correct.
All right. So I want to get to Sparky and the fire marshal, but let's look at the ordinance. Would you agree, setting aside the constitutional challenge, that if there is a conflict, if this court determines there's a conflict between the state law and the city's ordinances, that the city ordinance must be voided or struck down? Would you agree with that premise?
Justice Kittredge, if there is a direct conflict, you would be correct.
Okay.
I would.
Your position is there's no conflict.
That's
But you
correct.
accept the legal principle that where there's a conflict between state law and local law, state law trumps, correct?
Yes, sir.
All right. Let's talk about enforcement. You say the city takes on enforcement. You've told us something interesting, that the fire marshal is going to do it. What about reading the actual law? So what I'm hearing is a disconnect. I'm not supposed to follow the law passed by the city of Columbia. I'm supposed to ignore what's written and hear you say, trust me, we're not going to follow the ordinance. We're going to bring in the fire marshal instead, even though it's nowhere to be found in the ordinance. The ordinance places responsibility on persons. Each violation, $100. It adds up, subject to additional legal liability and sanctions, restraining orders, injunctions, and the whole enchilada. And then it defines persons so broadly to include teachers, principals, vice principals, any person who may have the ability to enforce this. And it even uses the phrase, etc., such an all-encompassing phrase. That's what the law is. How can that not involve the use of state-appropriated funds during this appropriations year for the enforcement of this ordinance?
Justice Kittredge, let me address that in 2 ways. The first is, the reason I was starting with the education campaign is this is entirely consistent with what the city did last year when there was a citywide mask mandate. If you recall, there was a substantial public education period, and only after that period ended did actual civil citations start to be issued. With respect to the schools and how it is currently working and how we expect it to work, you're absolutely correct. The ordinance creates the possibility of civil enforcement against the individuals responsible for the premises. And if you want an example of where that's already happening in the city of Columbia, think about the smoking workplace ordinance that the city of Columbia has. The city passed an ordinance in 2006 that charges employers with the responsibility of making sure that people do not smoke inside workplaces, including bars and restaurants. Prior to that time, a lot of people smoked in bars and restaurants. After that ordinance was passed, yes, just like with this ordinance here with the schools, it does give responsibility to the people on the premises who have control over the premises to follow the law and require people to follow the law. But as with the smoking ban, the city attorney's office looked, there have been 0 citations that they could find of smoking citations in the city of Columbia. And Your Honor, I think it gets to sort of
I want you to answer fully, and I apologize for interrupting you,
Not at
Mr.
all.
Kenny. Appreciate your presentation. But what I detect from the first answer and this answer is you're asking me, take my eyes off the law and trust us because we're really not going to enforce it. Look what we did with the smoking ban or with the bars and the restaurants. We gave them a pass for a period of time. We're going to be reasonable, so please don't get bogged down in what the law is. Trust us. How can we take our eyes off of the law passed by the city of Columbia?
Well, Justice Kittredge, that's not at all what I'm asking you to do. The city will enforce this ordinance when the education period closes and if there is noncompliance. All I was attempting to suggest is that people want to follow the law in this city, even if it's a law that they don't fully agree with. And the smoking ban is a good example. I'm sure a lot of smokers prefer to smoke in bars and restaurants still, but there has been no instance of a problem. I think Your Honor's question is really inviting, asking what happens if we have a recalcitrant 10-year-old who will not listen to the teacher when the teacher says, pull your mask up.
No, sir. What I'm asking is measuring the actual, clear, and unambiguous language of the city's ordinance juxtaposed to the clear and unambiguous state law and trying to determine if there's a conflict when it says the prohibition extends to the announcement or enforcement of such policy. I don't know how to read the city ordinance and conclude that there is no involvement with the enforcement by these people who are paid, at least in part, with the appropriated funds.
Well, Your Honor, I'd make a couple points about that. First of all, I'd refer you back to the proviso, which talks about the use of funds for this purpose, and no state funds are being used for this purpose. I do think it's, and we heard this, Justice Few asked about the $1 of state money that is washing around in a school district and whether that gives the Attorney General a hook to say, therefore, no mask mandate can be passed by a municipality. That is not correct. And if you were to accept that position, the Attorney General's position here, we would have a one subject rule problem. You could not read the proviso in harmony with the ordinance. And this court's precedent, whether you look at quality towing, fine liquors, and any number of other cases, you have always sought to read statutes in harmony with local ordinances, particularly where the state law has not directly addressed the matter at issue. And that is what we submit is happening here. The state simply said, we do not want you spending our money on this particular announcement, the requirement, the announcement, or the enforcement. That's the instruction. And that is exactly what's happening here. And
well, I think you should go back to your recalcitrant 10-year-old. And in that classroom, when the 10-year-old will not wear a mask, the teacher says, put on your mask. All right, so at that point in time, the teacher has required its student to wear a face mask. And that following the precise language of the proviso. Also at that moment, the teacher is earning a salary that is paid in part with state dollars. That's the conflict.
Justice Few, I think I deal with that in two ways. The first way is to, as I was saying to Justice Kittredge, I think it's the use of the state funds for that purpose. And so that brings us to this question.
So if the teacher says, Johnny, I'll give you $10 if you put your mask on, that's using money. But you're saying that the fact that the teacher's being paid a salary while the teacher is carrying out the responsibilities given to him or her under the city ordinance, that's not the use of state funds.
No, Your Honor, I don't believe it is because, first of all, there's two ways to deal with the use of the funds. I mean, one way is with respect to the Appropriations Act, there's a lot of non-state funds in the school district. So you could get into this discussion of, well,
38%. Let's just go 38%. So is the teacher standing at the front of the classroom requiring the 10-year-old to put the mask on while being paid a salary that comprises 38% of state dollars? Is that teacher not using state funds to enforce, to require the student to wear a mask?
And add to that the report to the assistant principal down the hall when the teacher says, kid won't do it.
yes, Your Honor.
So you got two people.
Yes, Your Honor. I don't believe it is for two reasons. First of all,
Well, but let me stop you right there.
Yes, sir.
To answer that question, you have to directly respond to Mr. Smith's argument that this can't be compartmentalized.
yes, Your Honor.
And you've got to explain that.
I don't believe so for this reason. First of all, the instruction, the verbal instruction by the teacher, that costs no money. It is no, now, I understand the
Well, that's a
concern.
little bit of smoke there. And mirrors are going to come soon after. So explain that.
Justice James, I understand the concern, but there's two ways to look at it. The first is the teacher is paid for, and like any other code of conduct, or any other city law, like smoking in the classroom, the teacher has been paid for, and it requires nothing more.
So the teacher's going to be there anyway.
Yes, Your Honor. That's one way to look at it. The other way to look at it, and we see this in a number of sectors, including education, where time has to be tracked in order to decide whether the appropriated funds or the grant funds that were issued, the time was actually spent in furtherance of how that money was intended. And we see that in education and a number of other sectors. I don't believe you need to go there. I believe that the instruction by the teacher is so de minimis, is so nominal, is so incidental to the daily work in the classroom.
What if you had an uprising of parents who said, we're sending our substantial block of students to Satchel Ford Elementary and not a one's going to wear a mask? Do you send all the fire marshals there that day to take care of no teachers being responsible or assistant principals enforcing?
Well, Your Honor,
I mean, these are examples that you appear to be ready to confront.
Yes, Your Honor. I don't think that we will confront that example for the reason I was trying to explain to Justice Kittredge. However, under that extreme circumstance, students generally follow the instruction of teachers and administrators, and the sort of parade of horribles that you've laid out in the hypothetical, which we don't think this ever comes to. Certainly, we didn't see that last year, but under that sort of hypothetical, it will come down to administrators to control the premises.
Mr. Kenny, does the city's offer to pay for enforcement include the offer of additional pay to the teachers for whatever time they might use for enforcement purposes?
Chief Justice Beatty, it does not. However, there are substantial 58% of the Richland 1 school district budget is comprised of local money. So that local money is there and available. And I would just say with respect—
So the money that is used for enforcement purposes can come from some other source other than the appropriations budget?
Yes, Your Honor.
Does the school district have any accounting mechanism that allows the differentiation of which funds that are spent on some purpose of what the source of those funds is?
Justice Few, I don't know the answer to that question, but I do think that your question refers back to Justice Hearn's concern at the beginning of this argument, which is the Attorney General has the burden here. There is nothing in this record to answer the court's questions about the practicality. And certainly Justice Hearn, one way you might resolve this case is to simply say, this is a facial challenge to a local ordinance. It's not right. And we will wait for an as-applied challenge where we can have some discovery.
Let me ask you one other question. Does this ordinance include a severability clause?
Your Honor, I do not believe it does.
But now, while you look for that, I want you to think you do have a constitutional argument that I'm certain that you want to get to, and you only have 3 minutes and 42 seconds left.
Chief, may I inject
Yeah.
something before? Let me talk about the role of the courts and what you're asking us to do and what you're not asking us to do. You're not asking us to decide the science, are you, about mask versus no masks?
No, Your Honor.
Well, let me finish my train of thought here. You're not asking us to make a decision in favor of or against mask mandates in general.
That's correct, Your Honor.
You're not asking us to decide the wisdom or folly of the proviso as far as science is concerned or the health of individuals in the community. You're not asking us to do that.
You're correct, Your Honor.
You're not asking us to decide whether masks are good or not good.
That's correct,
You're not asking us to decide whether masks in unvaccinated people versus masks in vaccinated people is a good or a bad idea. You're asking us to solely decide this case on the legal issues that you and the Attorney General have put forward.
Yes, Your Honor.
And that is it.
Yes, sir.
So you, both sides apparently respect the role of the courts in that respect. Is that true?
Yes, Your Honor.
All right, thank you.
And Justice James, if I can try to take your line of questioning and bring it back to the Chief Justice's question about the one subject rule or the invitation to address that. The City of Columbia has made a public policy judgment here, and that judgment is that the most vulnerable citizens in this city who are not eligible to be vaccinated, that would be people under the age of 12, the students who are in our elementary and middle schools, that a mask mandate is appropriate to protect them, and it's a valid use of the home rule police powers that municipalities and counties have. In terms of how we would like you to decide this case, I believe you can decide this case on the text of the proviso, which merely says the legislature has instructed the school district, do not spend our money on this particular item. That has never, looking at your precedent, that has never preempted a locality from exercising health and safety powers, and that is what the City of Columbia has done here. Perhaps not every city would choose to do that, Justice James, but the City of Columbia has, and this court's precedent has always given deference to validly enacted ordinances and attempted to harmonize statutes and ordinances when possible, and you can do that here. Now, if you accept the Attorney General's invitation, because I heard Mr. Smith answer this question on both sides. On the one hand, the Attorney General wants to say you were correct in how you construed the proviso in Creswick, and on the other hand, he wants to say, actually what the proviso says is, do not use the money, and any mask mandate by any governmental authority violates state law. You cannot have both. It's one or the other. And if this court comes down on the side of the second option, which is that all mask mandates by any county, by any city, are invalid pursuant to this proviso, you do have a one subject rule problem. And the one subject rule problem is this. Mask mandates have nothing to do with the Appropriations Act. It is not in furtherance or rationally connected to the raising or spending of money. Certainly, the General Assembly can come back next week and pass a blanket prohibition against mask mandates. They have the power to do that. What they cannot do, what the Constitution forbids the General Assembly to do, is to roll up a across-the-board prohibition into a one-year budget instruction that many legislators may not have even known was there, and then enforce it because there is $1 of state money washing around in a school district. Chief Justice Beatty, I see my time has expired. We respectfully ask that you enter judgment for the city.
Thank you very much. Mr. Smith, in reply.
Thank you, Your Honor. Going back to this funding issue, I referred to the Appropriations Act provisos. It's not cited in our brief, but Proviso 1.3 of the Department of Education appropriation says, to the extent possible within available funds, it is the intent of the General Assembly to provide for 100% of full implementation of the Education Finance Act by an allocation from the state aid to classrooms appropriations. 7.79% must be allocated to fully implement the state minimum teacher salary schedule with a minimum starting salary of $36,000. This is not a de minimis contribution. This is not $1. This is a substantial amount of money, and it cannot be segregated by saying, oh, a teacher will be not using her time for state-funded salary. She'll be using it for local. This is comprehensive. The ordinance ties directly into it. If the court wanted fact-finding, we could extend the case and do that. We don't
How about the
believe
ripeness issue? Is it ripe? I mean, we really don't know how this is going to work. It's hard to envision how it's going to work.
Well, Your Honor, we certainly can't understand all of these ramifications, but I think it's clear enough from the terms of the ordinance itself that it starts now with the ordinance in effect, and they have to comply or they're subject to fines.
And we couldn't sever that part, the part about the citations and the failure to comply, because there is no severability clause.
There's not, and it's all intertwined together. And if you're talking about severability as to the ordinance, there's also, it would be different if this proviso said can't use money to buy a mask. It doesn't say that. It says can't use money to require that students or employees wear a face mask. So that goes directly to enforcement. So does the ordinance, and they can't both be right. Proviso prevails.
Mr. Smith, can I ask you a question?
Certainly, Your Honor.
Even if there is not a severability clause, under the jurisprudence of this court, in an appropriations bill, and of course the city's bill is not an appropriation bill, it's talking about mask mandates, so I withdraw the question I was about to ask.
Let me ask you a question about the string of examples I gave to Mr. Kenny. You agree with his responses that we're not being called upon to do anything other than to use our judicial role to construe these two points of law, the ordinance and the proviso. You agree with that?
That is correct, Your Honor.
He mentioned at the end, I should have asked him this, but he mentioned at the end that there's a vulnerable portion of the population, K through 12 years old. Where does the role of the parents come in to have the right to tell their children to wear a mask or not wear a mask at school? We're not being called upon to decide that either, are we?
No, Your Honor, and the proviso doesn't say that children can't wear masks. It just says that funds can't be used to enforce a mask mandate. So
now let's get back to the point that Justice James asked you to say we are not here to decide. You've already said that this proviso does not prohibit mask mandates. Are you taking that back?
Your Honor, it says that state funds can't be used for that.
Okay, so it does not prohibit, it's not a blanket prohibition against mask mandates, is it?
It doesn't say.
I did not answer the question, Mr. Smith. Don't be an artful dodger. It is not a blanket prohibition against mask mandates, is it?
It is not, Your Honor, and if I may add to that, it is as
That's inconsistent with what you told me a minute ago and inconsistent with what you say at about 5 points in your brief. But
let me,
page 5, bottom of the page. Here's the quote from the opening sentence of the carryover paragraph. This proviso clearly prohibits mask mandates in the schools.
It does, provided that funds are used, and they are. That's what it means.
So only
Not
the funds are
intended.
used is what you're saying.
But I mean, you can't, I'm sorry, Chief, but you can't hide there. Okay, you got to tell the chief in answering his question that this proviso does in fact ban a mask mandate. You got an argument that doing so is legit. I'm not saying it's not, but don't tell him that this is not a blanket ban on mask mandates, because it is. You embrace that. Your position is that it is not possible for a school district to impose a mask mandate because of the proviso.
But that is correct, Your Honor, but because state funds are used.
I got that, but to answer to the chief's question is yes.
It is not a blanket prohibition without regard to funding sources. It doesn't say you can't have a mask mandate. It says you can't use funds appropriated to have a mask mandate. So there is that distinction. But
There's that distinction, but the state's position is that the distinction means nothing. Because as a practical matter, the effect of the proviso is that there cannot be a mask mandate in a public school in South Carolina.
the distinction is, does matter, Your Honor, except that state funds are necessarily involved. So in any public school, state funds would be used in enforcement and so therefore the city's ordinance would conflict with that proviso because it calls upon it penalizes the employees who fail to comply with the ordinance, and those employees are state funded. So that is the distinction here. I hope that I have made myself clear in these answers.
You have made yourself clear, Mr. Smith, that you understand reading a proviso in legislation. You've made yourself perfectly clear. That legislation does nothing more than what you said it does, and that is restrict the use of funding for the enforcement or announcement of mask mandate.
That is correct, Your Honor, but we believe that that is implicated here by this ordinance. And rest on my brief for the other arguments. And unless there are other questions, I thank you for your time today.
Thank you.
Thank you very much, sir. We'll be in recess. Yes. We'll take a 15-minute break before we start the next case. seated. You may notice that we are not wearing masks at this time, and the reason being that we are all vaccinated. So if you are vaccinated, if you choose to, you may remove your mask. Ladies and gentlemen, there were a few statements we made prior to the arguments in the last case. Now, hopefully you all were listening. And the point of fact is that we are not interested in the political arguments, political solutions. We are not here to make any medical statements or pronouncements. We're here to deal with the rule of law, and any decision that we make will be based on the rule of law and nothing else. Mr. Solomon, are you prepared to go forward, sir?
Yes, sir, I am.
You may proceed.
Thank you, Your Honor.
I understand you all are splitting time, 10-10. Is that correct on both sides?
Yes,
All right, thank you.
May it please the court, we thank you for accepting this matter on an expedited basis. As the warriors of the Wasa tribe will ask, how are the children? Today we have 1,220 students in Richland 2 that are under quarantine and 27 employees.
How many? 1,200?
1,220, 1,220 under quarantine. So we believe that the timeliness of this and the urgency was needed, and we thank you for that. I'll get right to it. Proviso 1.108 does not say what the respondents wanted to say, and it cannot do what they wanted to do. Simply put, if the legislature had the authority to put a ban on mask mandates in the budget, they would have said so, and they would have done that. This is about money. It is not about a mask mandate. What they did say was, if you spend quote unquote state funds approved or appropriated, and it's very difficult to know what that means, although I'll tell you what it doesn't mean in a moment. The threat is the Department of Education can take your state funds. This disincentive is designed to control the actions of school boards throughout the state on a policy issue and not to control spending. Richland 2 has $125 million, actually 124, 800 and some odd $1,000 that are local funds. In addition to that, this proviso has to address the 21-22 budget. Richland 2 has $80 million sitting in a bank account from funds appropriated prior to this year or from local funds. Those cannot be reached by this proviso. But where it does bring us is to a list of ifs and whats that take us down a rabbit hole and an abyss that we can never figure out as a district. What can we do? Can we take the $80 million that's clearly sitting in a fund and say we want to give supplemental pay based on time to announce and enforce a mask mandate and do so? I suggest to you the respondents argue you cannot, even though it's clear supplemental funds can be paid to teachers and other employees. This statute, and I'll get into the one subject rule in a moment, but the flip side is it's unconstitutionally vague, this proviso. It does not let a reasonable person understand what can and cannot be spent and not violate what is now this law. This is best illustrated by the respondents' different positions on what it means. Before the lawsuit, Respondent Spearman sent out a memo that says, districts may not create or enforce any policy which would require the wearing of face coverings. Should a district decide to act contrary to this law, state funding may be withheld. Not a little bit, not just what you spent. State funding may be withheld. That's a threat.
Well, if you got $80 million in the bank, why do you care?
Because they say the magical dollar floating throughout the district that goes to any percentage of which is funded, if a teacher says something, then we don't care if you pay them extra. Their position is, nope, nope, nope. Because they got a state dollar, that's still state funding.
Is that $80 million account segregated from state funds, or are the funds commingled?
It is both state funds prior to this year, so they cannot be covered by this proviso, and local funds, and it is absolutely segregated.
So there are no funds, and you mentioned a bank account, and I suppose you mean literally a bank account.
Literally a bank
Okay,
account.
so that bank account does not have any funds in it that were appropriated or authorized pursuant to the 2021 Appropriations Act.
Correct. So respondents Peeler and Lucas say they believe that it goes farther than that because of the magical dollar. Any state funds received, then you can't do it at all.
Well, Mr. Peeler says on page 13 of his brief that the proviso only applies to funds appropriated or authorized pursuant to the annual appropriations bill. It makes no attempt to address any other sources of funding. So is he agreeing with you?
That concession is correct. He is agreeing with us. Prior to the lawsuit, in a letter to the AG by respondents Peeler and Lucas, they asked him to challenge the city's ordinance because it was a ban on face masks. In his briefing, he does agree local funds and federal funds that go to the Department of Education straight to LEAs is not in any way approved or appropriated by the General Assembly.
So going back to my question, if they're going to yank 21, 22 funds from you, if you got all this other money, why do you care?
Well, we care.
Because you need it for other
We
things.
need all the money to educate the students of the district.
So how is all that money not necessarily commingled in operation? In other words, you got $80 million here, you got $80 million here. You know, pretty soon you're talking about serious money, as the saying goes. So in the end, why isn't all this money funneled to a general purpose of educating children, paying teachers, paying administrators, adopting or announcing and enforcing a mask mandate? How is it not all fungible?
We'll answer the question, but I think that is the best illustration of why this is vague. It is not commingled because it is in a separate bank account from separate years and local funds. The spending of it may then go and address something, but what we don't spend to address something, it is not commingled. So if I have 80 million here and 80 million there, we are allowed to spend monies that are unencumbered and unrestricted for the best welfare of the children. And if we choose that to be mask mandates, then that money would come from that segregated fund and not be commingled with the other.
Not to be facetious, but are you going to use different colored checks to pay people for one task and different colored check to pay them for another task?
No, sir, we're going to use general accounting principles to say you got to identify where the money came from, where you're holding it, and where you're writing it.
But when
so
you
it
write
does come out of a different account.
When you write a paycheck or a computer prints a paycheck to a teacher, the funds might be separated now, but by the time the funds reach the teacher, they're commingled.
Correct. But what we're suggesting is this statute says we want to use other funds, and it's clear you can use supplemental funds for incentive pay and other things. We could literally, we don't want to do this. We think this is an illustration for how unclear this statute is. But we could literally say every minute you spend on an announcement or enforcement, you got to write on a separate sheet of paper. And we're going to pay you out of funds that were not appropriated or approved out of 21-22. And it will not be that paycheck. It could be literally a separate check.
Well, you were watching, I'm sure, earlier when Mr. Smith, representing the Attorney General, says, yes, this proviso is about money, but the practical effect of the proviso is that this is what I heard him say, and this is what he wrote in his brief. The practical effect of the proviso is that this proviso executes a policy judgment that there shall not be a mask mandate in the public schools of South Carolina. It does it legitimately, he argues, but despite his, what I thought was sort of equivocating with the Chief Justice, he takes the position
He
that...
didn't equivocate. He went totally in a different direction. He made a statement that there is no mask mandate.
If that is accurate, then this is a clear violation of the one subject rule.
I don't know. You know, the legislature holds the power to use money to accomplish policy goals.
They hold power to do that. They should not coerce people into their policy goals.
Well, you may be right about that, but that...
And if they wanted to change the policy as they've espoused in Title 59, not a home rule argument, it's just clearly a different subject.
Of course, they're going to coerce people into their policy judgment. That's what the Richland County wants to do. That's what the city wants to do. The Richland County ordinance is the exact mirror of the city. It places enforcement on the school personnel, and the coercion is there because if the teachers and the people that work in the schools don't do it, they're subject to a host of legal ramifications and liability, starting with a $100 fine each.
When you start doing that with the disincentive of losing all of your funds, we believe that is improper under budget, number one. And number two, if the legislature wanted that policy, God, I hope they don't want it and do it next session. But they could, through the deliberate legislative process that would have committees, that would have people come testify before them, and that would create a general law.
We're back to the thing, you don't like their policy.
I don't like the way they did it.
Right. You don't like the policy, you don't like the way they did it, and it goes right into what the Chief Justice warned us about at the beginning of both these hearings, that Justice James has focused and emphasized is our limited role as judges.
Correct. If they had done it in a law as opposed to a proviso, not violate one subject rule, and if they had given us the ability for a plain person reading that law to understand what is implicated as prohibited activity and what are the penalties for it, I wouldn't be standing here. But they failed on both accounts. And so it is unconstitutionally vague on one side of that coin, and on the other side it's a violation.
Well, you know, the state that I don't think the state takes the position that there's any vagueness at all, and they're not coming down on the opposite side of where you are. They're coming down on the same side of where you are. They say that this proviso clearly prohibits all mask mandates. No confusion.
My time is up. May I answer?
You may answer the question.
They say that is clear. But what is crystal clear is when you ask them how, where, and what, it does not tell them, nor the people who have to follow this proviso, what is prohibited and what is the punishment. Laws are required to do so.
Well, we learned in the last case and I'm not offering an advisory opinion, but we were told, don't look at the ordinance that Richland County and the city have. Listen to us because we're going to use the fire marshals, and the fire marshals are going to infiltrate the schools and enforce this. Well, that might be a funding totally separate from Proviso 1.108. That might be a mechanism that separates the enforcement from state funds.
May I respond?
Subject to the chief. Yes, sir.
That is a separate funding. PTAs frying chicken and selling it at $5 a plate and donating it to the school districts could be a funding. A rich philanthropist or corporations that have already given masks could give more, and their local funds and their funds from prior years.
That's fine, and that might be fodder for another day, but what we're presented with is Richland County has passed the exact same ordinance that the city of Columbia has passed, with its infirmity of placing responsibility for enforcement of the ordinance on school personnel. I don't know how to avoid that and have it not conflict with the last sentence of 1.108.
May I, sir?
Yes, please, sir.
Number one, people, first of all, we believe it's de minimis activity, but assuming court disagrees with that, specifically answering the question. Employees of the district.
If it's de minimis activity, why are you going to fine them $100?
I'm not finding them anything, Your Honor. I can't answer
The
that.
ordinance says you are.
Not me, Your Honor. We're the
That's
school
the city.
district. We're here saying, God, we need help.
Sorry.
This is unclear.
Sorry, Chief, and sorry, Justice Kittredge. No.
Justice Kittredge, we can supplement funding. So if we have to say, my goodness, there's a state proviso and there's a county rule and we're trying to follow everything. How can we do it? We could go in and say, keep your time. We don't want to do that. And we'll pay you for the time necessary to enforce this county ordinance. And if we did that, then there would be no violation and there would be no expenditure of state funds. Thank you very much.
Thank you, sir.
I don't think it's fair for Mr. Solomon to be bringing up fried chicken right before lunch, Chief.
Counsel, you may approach. Ms. Hutto.
Your Honors, Skylar Hutto appearing on behalf of petitioners. May it please the court. This case presents numerous issues to the court, as you've heard. I would like to address the particular challenges that have been presented to the petitioner mother in this case, whether or not her children can receive an education in this state, and whether or not her children can receive what is constitutionally required, a minimally adequate education in this state. As it stands, she, like many others in this state, are in an impossible situation. Her children have been in the same school district for their entire lives and now face a new dilemma. One of her children, a man too young to be vaccinated, has a respiratory illness that makes him particularly vulnerable to COVID-19. Her children's school district cannot meet her needs on two levels. First of all, it cannot provide virtual schooling because it's at its capacity for virtual schooling. And secondly, it cannot make in-person schooling minimally safe enough for her son to attend.
Is that because of the proviso or for other reasons?
Well, Your Honor, we contend that the school's apparent prohibition on being able to follow CDC guidelines for schools.
If everyone was required to wear a mask, would the child be able to go to school live?
It would certainly be safer, and that is our contention.
Would the child be able to go to school live?
I believe in the instance of one of her children, the one that has a respiratory illness, it could still be of such a great danger that virtual schooling would be vastly preferable.
So you're here talking about 1.103, is it?
Right. Your Honor, I'm here to address the concerns of the court on both, on behalf of the petitioner mother.
Will we put that one up, please? All right. Go ahead.
This court has addressed the need for safe education in the past on several occasions and has been defined as minimally adamant education required by our Constitution includes providing students with adequate and safe facilities. And to your point, there may not be a way to make facilities 100% safe, but there is a way to make them safer. And we believe that that is exactly what is not accomplished by a ban on mask mandates. By preventing schools from requiring masks or also preventing them from returning to their homes to learn when infection rates may be at their highest, the General Assembly has not only prevented some of the safety measures that school administrations may want to take, but they have actively made schools less safe through that prevention. School districts and educators create restrictions all the time that are designed to make schools more safe. For example, smoking is banned in schools. Students in schools are required to wear clothes. Students in chemistry class have to wear goggles, and students on the football field have to wear helmets. These are all normal things that we expect, and that authority to create those requirements is given to school districts in Title 59. We contend that both of the provisos at issue here are in conflict with Title 59 because Title 59 says that school districts can create standards of conduct and behavior that must be met by all pupils. And of course, wearing a mask is a standard of conduct that directly impacts the pupil, directly impacts other pupils, and directly impacts the minimally adequate safety of the school.
Are you suggesting then, Mr. Hutto, that the state has no right to override that? That the state is not plenary in its power?
The state, through the General Assembly, does have plenary authority over several things. However, what we have here is a proviso, not a newly passed policy. Although I believe the interpretation that the state is advancing is that it is a newly passed policy. But what's different here is that the state is attempting to use a budgetary measure that includes the magic words using appropriated funds or of state funds to then create policy that is typically governed under Title 59, which would be the policy or title that covers the education and safety within schools.
It sounds like you are suggesting then that is violative of the Constitution in some form or fashion.
I believe it's violative of the Constitution, not only on the grounds that it prevents schools from being minimally safe in that they are prevented from following CDC guidelines, but also that the passage of these provisos is violative of the Constitution is log rolling. We have contended that in our briefs, and I believe that we've put that forward in several ways. I think this is the clearest example, and Mr. Solomon touched on this as well. The legislature has said that state funds cannot be used for a mask mandate. However, on page 12 of the briefing from Speaker Lucas, there is a statement where the state concedes that schools could use state funds to
Second
purchase.
paragraph on that page.
I believe so, Your Honor. State funds can be used to purchase masks, apparently. That is the most direct possible expenditure of funds in furtherance of a mask mandate, would be to literally buy the masks and give them to the schools so that the schools can provide them to students.
It would seem to me the most specific policy in furtherance of a mask mandate would be a teacher or an administrator saying, you must wear the mask I gave you.
That does not require the expenditure of any additional funds. I believe you heard a little bit about that in the case prior to us.
It doesn't have to require expenditure, it has to be reasonably related to. Isn't that the rule?
The expenditure has already occurred in this example by the purchase of the mask. The teacher's salary is already funded. To the extent that it's not already funded to undertake this behavior of requiring that the student wear the mask, we contend that that is easily funded through local sources through which the provisos have no control, or over which the provisos have no control.
So we're back to the commingling of fungible money.
That is not the only issue at stake here. What you've just described would be an issue of the statutory interpretation or plain reading.
Right.
But I'm also trying to address that this is a log rolling issue as well, because the expenditure at that point that has to be rationally related to the budget has already occurred. Anything beyond that is an attempt to...
When you say that regarding the salary of the teacher or regarding the mask?
The mask. Although it would apply to the salary of the teacher.
Well,
too.
the salary of the teacher, the expenditure to pay the teacher doesn't occur in a one-time lump sum at the beginning of the school year. It occurs incrementally over the entire school year.
Perhaps I should say it's already budgeted for at that point. But there could be a one-time expense.
But it hasn't been spent.
It has not been spent to the extent that the funding of the teacher's behavior occurs. There's ways to fund it, as Mr. Solomon indicated, without implicating any of the funding listed in the proviso, which would be the appropriated funding.
What if the school district said, we're actually going to take these teachers out of the classroom for an hour a day and have them go out and cut the grass on the baseball field? That would be using state funds to cut grass on a baseball field, wouldn't it?
Well, they would be using presumably state resources as well. If the state was ordering it, yes. In this instance, there's a distinction because there would be local authority that would pass a mask mandate if they wanted. That is not, in your example, if the state ordered teachers to do that, that would be the state ordering it. We're talking about local control, which is the type of control that is contemplated in Title 59, that school districts will make the determination about the conduct that each pupil has to engage in to attend the schools. With respect to whether this is a live controversy, which is something that I believe both respondents brought up in one space or another, I would like to emphasize that it is. Obviously, you've been here twice today to hear very similar cases, but I would like to point this out. There is need for determination from this court in some form. Federal agencies, as you've seen in some of our exhibits, are telling school districts that they need to engage in mask mandates for the safety of their students. State agencies are saying that no funds can be used for this, and the government is saying that there is a prohibition on mask mandates. This is not something that the school district takes lightly in challenging the state's action. As the respondents have noted, there is a general wariness of the court to acknowledge public officials that challenge state action.
I mean, the timing of it does seem like it was done in response to the proviso.
It absolutely was, which I believe furthers our question, or furthers the importance of doing this. And furthermore, I would note that the teachers themselves are placed at risk through their inability to defend themselves in this situation. I see that.
Well, they can wear a mask, though, if they want to, correct?
They can. However, may I answer that question?
Yes.
They can. However, as we've made available to the court through the CDC guidelines, it is not just one's own ability to wear the mask, but the ability to encourage others to wear a mask that the CD recommends is safe.
Thank you very much. Ms. McWilliams.
Please, the board. I have the privilege of representing Speaker Lucas, and in preparing for this, I was drawn to, because of the citations of the Abbeville cases, I was drawn to Justice Kittredge's dissent there, because just like, although it's not a perfect analogy to the Abbeville cases, what the petitioners are asking is that this court elevate personal policy preferences to constitutional status. They're saying this is unconstitutional. And there's undoubtedly an emotional appeal to what Mr. Solomon and Mr. Hutto have said, but the court, and I believe Chief Justice Beatty, you said this at the very beginning, we're going to decide this on the rule of law. And as this court said in Kaiserling, it doesn't sit as a super legislature, but that's essentially what is being asked of this court today by the petitioners. The General Assembly is the governmental branch with the authority to appropriate funds and to make, and in fact, through the conditions that it places on the spending of those funds, to effectuate policy. The General Assembly is the legislative, or the governmental branch, which considers the arguments, the pleas, the urgings of the petitioners, but it also considers and takes into account those rights of parents to make a determination with respect to how their children are brought up, and that includes their health and wearing a mask. I want to be clear. I think, Chief Justice, you may be getting ready to ask me, is 1.108 a ban on masks? It's not. It's a ban on mask mandates. The legislature has made...
Now tell me where in reading 108 does it say it's a ban on mask mandates?
With the use of appropriated or authorized funds.
So you can't use funds from the 2021-22 budget to enforce a mask mandate. That's what that says, isn't it?
Well, it says that, Your Honor, but with respect, and I
mean, are we to go outside of what it says? And if we are to go outside of what it says, tell me what is the premise for doing so?
You don't need to go outside what it says, Your Honor, but I think the practicalities, which this court has discussed in the previous case and with my, in the previous arguments with Mr. Solomon and Mr. Hutto, the funds that are appropriated by the state, which the legislature has the authority to appropriate and provide to operate schools, those are fungible. They get put in an account, and I think the argument I heard today, which was, well, we're not going to pay, for the first time, we're not going to pay them with state appropriated and approved funds. We're not going to do that.
No, without state approved fund from this appropriated budget year.
Yes, Your Honor. But the practicality is that as soon as a teacher takes steps, or an administrator or an enforcer, whoever, unless they're going to literally hire someone with absolutely no use of any state appropriated funds or approved funds, which is not what I heard them say. I thought I heard them say, we're just going to let them keep their time, and we don't really want to do this, but we'll let them keep their time, and every time they do one thing that might be in furtherance of a mask mandate, well, we're going to cut them a separate check. As a practical matter, that is I think, unworkable. It's the first time.
Says who? That says it's just an accounting matter. technique, method. Why is that such a problem?
Well, I don't think.
I mean, they pay a lot of different accounts. They owe a lot of bills, and they make different payments to different people all the time.
Well, that's what I've heard today, Your Honor, but as a practical matter, when teachers and administrators are enforcing a mask mandate, it isn't simply, well, we're going to we'll send an email to everybody, or maybe we'll put up a poster, but the time they spend, I've never heard that the teachers and administrators are only going to be paid from local funds or funds that are not subject to the proviso. And I think as a practical matter, that's not what's going to happen.
Well, then doesn't that get us back to Justice Hearn's point that this might be premature?
Well, I think as I said, for the first time today, we heard about this separate fund, that there's a separate bank account. But as a practical matter, there are a lot of factual issues raised by the petitioners, but what's before the court is, does the legislature have the authority to enact these provisos and specify conditions on them? And I would submit that they...
Well, no, that's not the question here. The question, well, that's one of the questions because they're saying it's unconstitutional. The question that I am concerned with at this point in time is whether or not that proviso prohibits mask mandates. And if it does, and if that's your position, I want you to show me where it says so in the wording up there.
I would say, Your Honor, I think the funding issue, which it does not say there can never be a mask mandate, but it says is...
In fact, it could not say that, could it? Excuse me. In fact, in a budget proviso, it could not do that, could it?
Well...
Mr. Moffitt knows that, I'm sure.
I think that's right.
But they perhaps could have done it in a more general law.
In a general law,
they chose
without
not to do that.
I think that's right. They could have done it that way.
We've been dancing on the head of this pin all day, but you're telling us that while you agree with what they just told you, it's actually more than that. As a practical matter, there cannot be a mask made in a public school in South Carolina.
Using appropriated funds, and
but then you circle back and say, but it doesn't matter about that because you're always using appropriated funds. Therefore, there can never be a mask mandate in a public school in South Carolina.
At this point in time, I think that was the intent of the legislature. They've made a determination.
That's not the question. The intent of the legislature at this point, going back to, excuse me, the intent of the legislature is always something that we should be concerned with. But going back to Justice Few's point, you are now saying it cannot be done absent utilization of state funding from this appropriation bill. What about Mr. Solomon's accusation that they have $80 million sitting in another separate banking account?
Well, I thought, in addition to Mr. Solomon stating that he had a separate, that Richland 2 has a separate bank account, and that, of course, puts aside for the fact that all those school districts that may not have $80 million sitting in a separate bank account. He conceded that they were eventually commingled in order to pay teachers and administrators, and it's just simply, I think, inconceivable that a teacher is going.
But that money didn't come from. That money did not come from this particularly appropriated budget year. Well, and that's the only thing that proviso restricts, is it not?
I think that's right, Your Honor. But when they put it in with funds from this year, they've commingled it, and then it implicates the proviso. I think is, I thought that's what I heard. They conceded that they were commingled. And
let me ask you about the statement on page 12 in your brief.
Yes, Your Honor.
The second paragraph. There are a number of actions a school district can take without violating the proviso, including purchasing masks and making those masks available to students and employees using state funds. Teachers and other employees, while being paid their salaries from state funds, could even suggest or recommend the others wear the mask. You stand by that?
Yes, Your Honor, I do.
Okay.
They can't require it. They can't say as soon as...
Ms. McWilliams, if we didn't have the enforcement provision involved here, what would your position be then as to whether or not the school districts could do this?
Well, I can't...
Because, I mean, you've said they could recommend it. That's like a step right before saying you must put your mask on.
Well, but is it really? Because that's, Justice Hearn, you've hit on the real key. This proviso, 1.108, covers, includes specifically the announcement or enforcement. And I think it's would be disingenuous of me to suggest, well, enforcement, you just run around and kind of say, hey, you, put your mask on. Or the fact of the matter is, it's the requirement of the mask. It's up to the
Announcement without enforcement means nothing.
It means nothing, and it wouldn't be a mask mandate. I think.
Look at what Superintendent Spearman did on buses. It ostensibly appears to be a mask mandate, but it all comes down to a final sentence. Quote, no student should be denied transportation for failing to adhere to the CDC order. So there's a recommendation, there's an encouragement, there's a support of that policy. But there's no punitive aspect or tentacle to it that someone's going to be fined or expelled or suspended or put a teacher or some other enforcer between here, the Richland County ordinance, and the state law.
That's correct, Justice Kittredge. And I think there's a huge difference between encouraging masks and requiring it and enforcing that. Do you pull the child out of school? Do you call the parents from work and say, come get your kid? Little Robert McWilliams is not wearing his mask. He won't do what we're telling him to do. The fact of the matter is that would be an unworkable situation, and it obviously would implicate the spending of state funds. And I see that my time is up.
Thank you
there
very
are no
much.
further questions. Thank you very much.
We do appreciate that. Mr. Moffitt.
May it please the court, my name is Kenneth Moffitt, and I am here to represent Senate President Harvey Peeler in this matter. And if I may, I'd like to address some of the points that have been raised to date, and starting with the question of vagueness. Petitioners claim, their argument is you can't look at the proviso and tell what money we're dealing with here. Well, you have to look at the proviso in the context of the Appropriations Act. And in an Appropriations Act, there is always, and in this one there is too, a statement of revenues that lists every single source of revenue that's being appropriated or authorized in the Act. You flip to that page, if you're looking at a source of revenue and you say, okay, this is the source, was it on this list? You're able to tell exactly what's being controlled by the Act because the list exists. To the question of, there seems to be a question about how a proviso operates in relationship to a statute. I think the petitioners are trying to create a false hierarchy of enactments of the General Assembly. Somehow statutes are superior to provisos. They're all law, aren't they? Yes, sir. As this court said not too long ago in the Amisub versus SCDHEC case, an Appropriations Act has the equal force and effect of law as a permanent statute. So each one of these provisos, 1.108, 1.103, those are the policy decisions made by the General Assembly.
The suggestion is that somehow the General Assembly is restricted as to which policy decisions it can implement using budget provisos as opposed to general laws. And you take the position, I suppose, that there is actually no limit. If the General Assembly is appropriating money, it can put any condition on the expenditure of that money that it pleases.
Well, there are always limits. And the General Assembly's limit, and the limitation in this instance, is that it has to be reasonably related to raising and spending revenue, and it has to be directing the manner of the action, of the expenditure. So the subject of an appropriations bill is to provide for the ordinary expenses of state government and to direct the manner in which those expenditures are made.
Now, you're taking that from the Georgetown water and sewer case. And specifically, that quote says solely, you left out that word, solely, the subject of an appropriation bill is solely to to make appropriations to meet the ordinary expenses of state government and to direct the manner in which the funds are to be expended. Is that correct?
That is the subject of an appropriation.
What is the import of the use of solely?
Well, it means that that there's a limit on exactly what the legislature can reach out and touch in an Appropriations Act, and these provisos don't exceed those limits. And this proviso, it's saying that any funds appropriated or authorized pursuant to this act. So you're able to look into the act and see, is it appropriated? Is it authorized? If so, those funds are off limit.
I'm glad you brought that up. In your brief on page 22, there's a footnote, note 7, where you say, upon the information that believe funding from the federal government pursuant to the American Rescue Plan Act, elementary and secondary school emergency relief received by the state was dispersed directly to the Department of Education to be distributed to school districts. Are those funds in that list of things in the appropriation bill? No. I don't know. They are not.
No, sir, they're not.
So those funds could be used for the enforcement of a mask mandate.
Those funds potentially could be, but I think that leads to the next problem that we have, and that's the problem of asking for an advisory opinion. Those funds exist and they're there for school districts, but the rub, as we've seen all day, is what's your plan? What's the plan of action for a school district? Yes, sir.
Are you begging for another round of litigation? For example, if we just say, okay, no advisory opinion on that, Mr. Solomon, Mr. Hutto go to the school district and say, let's use the ARP money. Are you going to come back with an attempt to enforce the proviso and have to file another suit and say, no, we don't think you're doing it right? Well, try it again with another source. We don't think you're doing that right.
Well, I think what we're actually trying to say is that it's not justiciable at this point, because the funding question, where's the money coming from? That's only the first question that comes into play in one of these situations, because as has been discussed, enforcement, commingling. Is a teacher going to put on her hat, being paid by the state or not? These are all fact-based questions that haven't been presented to this court. So respectfully, what we pose to this court is that if you were to sanction the use of, just simply say, any money that's out there other than what's appropriated in this act, I don't believe that you are entirely sure exactly what you're sanctioning. And
you're saying that that's all fine, except for the reality that the only way such a mandate, legitimate in the abstract, could be enforced would be to call the teacher and the principal and the school hall guard or whatever into the action of enforcing the mandate, which in turn implicates state dollars, which in turn violates the proviso.
Yes, sir. And it goes beyond that to the announcement, to any one of a number of questions that are left.
If they took those federal funds that y'all were just discussing, or if they took the segregated $80 million of previously allocated funds and local funds and hired a new teacher's assistant to go into each classroom using a bank account that never was commingled with state funds, maybe then you've got a way of carrying out a mandate without using state funds. You would probably tell me that they'd even have to go build a new school with those funds and not use the floors that are mopped with state-paid janitors and things of that nature.
I think we can go down a number of hypothetical paths, but the fact is we don't know. No one showed us a plan. How are we going to make this happen? By we, I mean, how would a school district make this happen?
Should we refer this to a special referee to take evidence and make findings of fact on how it is going to work? Because it seems like we're all just speculating here.
I think the court should, I don't deem to make a recommendation to the court about.
We take recommendations. Do you have one?
Well, I think that the court should withhold the decision on that matter until there's an actual case in controversy brought before the court.
And I want to be clear about what you're saying there. You think there is a case in controversy about the current ordinance. You're saying that if there were some proposal that would in fact use only these non-2021 Budget Act allocated funds, then you have a situation where there's no case in controversy. Am I wrong?
I haven't researched those ordinances and those. I mean, I think there are separate questions also in play with them. But I do believe that it is ultimately a fact-based question that we don't have facts in front of us to answer it.
So why'd you agree for us to take this case in our original jurisdiction? We've done no fact finding. We have, between last week and today, we haven't had the capability.
Well, because there was a threat to the existence of the provisos under Article 3, Section 17. There was a challenge to the constitutionality of the provisos.
Okay, I got you there.
But
You didn't bring this case. They brought the case.
Yes, sir.
You agreed for original jurisdiction. And I know you've been invited to chase a bunch of rabbits here, but the reality is they rely on the Richland County Council ordinance as the enforcement mechanism. So to the extent we have that before us, that we have a justiciable controversy, and anything we do would be without prejudice if they want to take another stab at it through a mechanism that does not involve the appropriated authorized funds pursuant to the act.
Well, I would argue that the statewide policy enacted by the General Assembly supersedes anything that one of the...
Oh, so you're back to saying this proviso really does ban any kind of mask mandate?
No, ma'am. No, ma'am.
Well, it sounded kind of like that.
Well,
Help me with that.
it's a fine point that's being, both sides are kind of dancing on either, and I can, I recognize that. What this does is it prohibits the use of funds to announce, enforce, impose a policy. That carries with it
But it doesn't ban the policy.
But what the proviso does is it carries with it a result of what the words say. You take the words for exactly what they are written on the page, and then what that means is
it can never be a mask mandate.
Oh, no. I don't know how you get that out of that statement.
Well, that's you're saying that.
Well, it means there can never be a mask mandate if it's using state funds. Petitioners have argued that there is another way to do that. But what they haven't done is they haven't shown you a plan. They haven't put in front of you specifically, these are the specific things that we're going to do. They've identified.
Well, let me ask you this.
I'm sorry, my time is
up, but we're going to ask this question, and hopefully you will have an answer for me. Even assuming what you say is true, and I'll accept it, supposing then, you're saying this is premature, this has not happened, well then, suppose they go forward with it, then what? Then what?
They go forward with one?
Yes.
Well, I think at that point, should someone object to it, they could, unfortunately, find themselves back in court. But at that point, it's justiciable. At that point, we know what their plan is. We know what their source of money is, how it's enforced. All the questions that are unanswerable today, we would have answers.
So they have to wait until there's a threat to their funding before they can come back to deal with this issue.
The threat to the funding question is they are under the obligation to follow the laws that are passed by the General Assembly.
That's an answer. That's an answer. That's a response that is not an answer.
Within that proviso, there is no threat to their funding.
All right, sir. I do appreciate it. You've helped us tremendously, Mr. Moffitt. In this thorny issue, I see there's a question over there from Justice James.
Addressed briefly, and I suppose Mr. Solomon will reply your argument that Richland the school district does not possess separate sovereignty and can't sue its creator, which is the state. You still rest on that?
Yes, sir. We're in that it's a Court of Appeals case where the Court of Appeals reasoned that in a suit with Georgetown County, that because the county was a county created by statute like school districts, and that that they didn't therefore possess a separate sovereignty to sue the Department of Transportation. We think that the reasoning that underpins that case, you can find it here. Again, creatures of statute suing the state. It seems to be a fairly, if not exact, apples to apples argument, but very close.
Thank you, Chief.
So are you suggesting that there could never be a suit between the city and the state, or a city and a county?
I'm suggesting that the reasoning in the Court of Appeals makes sense and should be adopted by this court.
Thank you, sir. Mr. Solomon, in reply.
I think we come back right to where I started. This doesn't tell us what's forbidden and what's allowed.
Well, it says you've not done anything yet.
Ms. Spearman was a little more aggressive than that in July in the memorandum that's attached to Dr. Davis's affidavit. And she says if you do it, you may lose your funding. So we believe that this is a controversy that has been threatened to be enforced, and therefore needs to be addressed. Likewise, in the Thompson case that you cited years ago.
So the controversy is the proviso versus blank. And I think that's what the questions are getting to establish that there's an existing controversy. So the proviso versus what are you going to do?
Well,
all we have here is you submit the Richland County ordinance, which places full responsibility of enforcement on the school personnel.
Two things, if I may, Your Honor. Number one, in the Thompson case, you guys, the Supreme Court decided that it was of such public importance that the declaration needed to be dealt with. And in this case, it is in every school, in every county, in the state of South Carolina.
So what does our order say?
If I were writing the order, Your Honor, I would say that the proviso is written, cannot address other funds. But as written, it does not say to a normal person, standard under vagueness, what is allowed and what is not, and therefore it is unconstitutional.
So we hear today for the first time that what your provision is you have $125 million from last year or some other funds local that don't involve the 21-22 state appropriated funds, and that you can cut checks and teachers can keep time slots and other personnel. And I guess you'd cut a separate check when they use part of a bulletin board to place the announcement, or you use part of a computer to send an email. You just will go to that separate fund and catalog that time and reimburse the state or someone for those efforts?
Two things, Your Honor. Number one, the existence of local funds and federal funds that are not governed by this proviso was not raised today. All I did was give a number to what Respondent Peeler already acknowledged exists and is not implicated by the Appropriations Act. So everybody, in terms of the respondents and the petitioners, knew that they were local funds and they were federal funds that are not in the list that goes to the proviso.
And we still are clueless as the mechanism that the Richland County School District would use to enforce and fund a mask mandate.
Solely because that proviso is so vague and these arguments are so unwieldy that we don't have the ability to say what they would consider in violation and not. And I believe that is the standard for it is not a law that could be upheld and can be followed. The flip side of that coin is, why is that? And that is because it ain't about the money. We can buy the mask. We can talk to the students about the mask. We can put up signs. They just can't say, you must wear your mask. It's not about the money. So the proviso is addressing a policy that is not money related.
Yeah, I've been trying to get everybody to talk about this all day, and I agree with you that the policy that is embedded in that proviso is not about the money. It's about masks. But the question is whether the state has the power, using a budget proviso, to implement a policy that is not about the money.
I would say no, because it's not related to the raising and expenditures of funds.
But they use the money to get there.
And
that is about the expenditure of money.
Taking that to its illogical conclusion, the General Assembly can then violate the separation of branches, can go against any law that it previously written in the proviso, as long as they say, to help with the raising and expenditures of money, don't use state funds to do this.
Now, setting aside your constitutional points there, because they couldn't do that in violation of the Constitution, but why can't the General Assembly use its expenditure of money, its appropriation and authorization of money, to accomplish any policy it wishes to accomplish, so long as it doesn't violate the Constitution?
Well, we believe it does, because it gets into another subject.
Right, but separate question. To the extent it doesn't, nobody disputes that the General Assembly, I don't think, nobody disputes that the General Assembly has the authority through a general law to impose a ban on mask mandates. Why is it not true that the General Assembly has that same authority to carry out that same policy through the Budget Act by saying you can't use money to get there?
May I respond?
Yes.
And then when I finish, I'd like to make one closing statement. We believe that the General Assembly has the authority to do it in a regular law. We do not believe they have the authority to do it on subjects like this in the proviso, because it violates one subject. Additionally, when you talk about influencing, suggesting, coercing, there are different levels. This one has absolutely no limitation on funds, and the director from the Department of Education said you may lose your state funding, which can be in full if you read it on the plain words. We believe, Your Honor, just like the Supreme Court of the United States that has said the Congress can put stipulation on funds, when you get to the point of we're going to pull all your funding if you don't do this one thing, that's too much. Now, I can't tell you whether it's 5% or 3%. If you lose 100% of your funding on a policy issue, it's not about the money, it's about the policy issue. Thank you very much for listening to us. I'd like to leave you with this very briefly. The sacred trust the people have placed in the General Assembly of South Carolina to provide safe public schools as required by our Constitution, we believe should not be infringed upon for political gain. And we believe by going into this other subject and addressing this in a way that is not clear to the average man, superintendent, trustee, and I don't know what you're thinking, but I would even suggest to you, based on your questions, cannot be a constitutionally solid proviso. It is constitutionally vague, unconstitutionally vague. Thank you very much.
Thank you very much. We are adjourned.